were sitting on the side could sit at the table. What
Yeah,
is
yeah.
that?
Por favor, todos en la mesa, por favor, los...
It's more a discussion.
Good morning. On behalf of our Dean, Héctor Fix-Fierro, I would like to welcome you all to this seminar session with Professor Dworkin. And I would like to start by acknowledging that he not only accepted to deliver the lecture, but also asked for, insisted, and encouraged to have a seminar session to discuss the lecture and also to discuss any other piece of his work and probably any other idea on legal philosophy, jurisprudence, legal theory, political and moral philosophy as well, which will be of your interest. The idea is to have like a lively discussion, but for the sake of the persons who were not here on the lecture, I will probably start asking you to give us a summary of your main arguments, and then we can open it to a discussion from the table. I don't know how long would you like to speak, but
You tell me how long. 5 minutes?
No, probably 10 if you
Maybe 5 minutes or
Okay.
to 10 minutes.
Okay, 5 to 10.
Because I want to leave as much time for discussion as I can. In the lecture yesterday, I had two ambitions. First, in a more practical, lawyer-like way, I wanted to discuss the legal argument in favor of breaking down the traditional assumption that law is tied to political communities. And I began by mentioning two examples of how this seems to be breaking down. The first is the extraterritorial jurisdiction now claimed by several states. Great Britain tried General Pinochet of Chile, and in the end, on medical grounds, did not extradite him to Holland, where Spain, where Spain was anxious to try him. Just a few weeks ago, a German prosecutor announced that he was going to prosecute Donald Rumsfeld, who, as you know, has been the Secretary of Defense of the United States, principally charged with the prosecution of our war in Iraq. Now, these are extraordinary claims because the events of which Rumsfeld is charged took place in Washington and other parts of the United States and in Iraq and other parts of the world. None of these events took place in Germany, so far as we know. And nevertheless, the claim was that a German court could hold Rumsfeld responsible. So that's one example of the law breaking through the traditional assumption. The second example, longer standing, is the practice of courts in many nations, and now finally, even in the United States, of citing decisions of foreign courts in their decisions. I mentioned two cases. The first was a case in which the question arose whether it was constitutional for one state of the United States to execute a child or someone who, when he committed the crime, was only 14 years old. The Supreme Court, in a very divided vote, held that that was unconstitutional, and Justice Kennedy, who wrote the opinion for the court, cited decisions of many foreign courts and also of the European Court of Human Rights. Similarly, in the more recent case called Lawrence in Texas, a case holding that the states could not constitutionally make homosexuality a crime, the justices of the Supreme Court cited decisions of foreign courts holding that it would be a violation of human rights to punish someone criminally for homosexual acts. Again, this breaks down the traditional barrier. What business does a court in Washington have in citing decisions of courts in Strasbourg? It may sound not so surprising to you, but in the United States that is very surprising. And it evoked a very considerable outcry among other justices on the Supreme Court. I tried yesterday to offer a rationale for both aspects of the breaking down of the traditional assumptions about territory and law. My second goal was to argue on a more abstract philosophical level for a view of law, what makes a proposition of law true, truth in law, for a view of all of that, which allowed the practical argument that I made first. My claim was that the close association of states with law, the idea, as I put it, that law comes in state-sized bites, so that a court has no business citing foreign law, and a court has no business punishing people for acts that took place abroad. I claim that that's very much tied to legal positivism as a theory of law. And since, as some of you know, I reject legal positivism as an inadequate theory of law, I'm anxious to show how an alternate theory of law, which I've been trying to defend for several years, makes room for the kind of argument that I believe we need to deal with the international aspect of law. I have been arguing for some time that law is a branch of morality, particularly political morality, not something distinct from morality. That raises the question, what is the particular moral purpose of legal reasoning? And I argue that it is integrity. The state in matters of principle should speak with one voice. If it cites one moral principle to justify how it treats one group of citizens in one group of cases, it must in principle respect that same set of principles in other cases dealing with issues involving other people. That's the idea of integrity. It's a kind of coherence of principle. And then I argued in the last part of my lecture that integrity applies not just within states as conventionally understood, but now applies as a requirement of legitimacy to the acts of what I called the international community. And I described the international community as those nations that recognize two fundamental principles that I think are the fundamental principles of human rights. The principles of dignity, first, that every human life is of intrinsic and equal importance, objective importance, and second, that each one person is responsible for each life, namely the person whose life it is. And in other work, in my most recent book, which is called Is Democracy Possible?, I try to show how a theory of human rights can be developed from those two principles. Yesterday, I claimed that the international community consisted of those nations that recognize those two principles as the foundation of human rights, though they disagree about what in particular those principles require in particular cases. Integrity in the domain of the international community and human rights means that the international community should be striving to work out one answer to the question, what do those principles require? So that the community speaks with one voice in Bosnia, in Iraq, in Darfur, in the prosecution of war criminals, in the decision whether Donald Rumsfeld is a war criminal, for example, and in the decision of such matters as to whether it is a violation of human rights to execute children, or whether it's a violation of human rights to criminalize homosexual acts. If you agree with that there's a case for supposing that the international community should speak with one voice on these matters, that integrity applies at that level, then you will accept the need for what we might call an international common law of human rights. And the idea of an international common law of human rights is what I think lawyers, legal philosophers, international lawyers, human rights lawyers, constitutional lawyers should now be trying to develop. So my third aim is to encourage that process. Perhaps that's enough of a summary too.
Okay. Does anyone have questions? Comments? Discussions? Manuel Becerra, por favor.
So the last point is very interesting. My question is, you are talking about the international community.
Yes.
And also that there is one voice of human rights. And the human rights is common for all mankind, you can say. My first question is, who decides who are the human rights, first of all? And if there are some states or cultures that are not according with this general principle that you are talking about, it means that these cultures are not part of the community?
Yes.
This is the big question that I think.
Yeah.
Right.
Well, you have asked two questions.
Mm-hmm.
Your first question is who decides what the human rights are. And what I meant to suggest is that we must give the same answer to that as we give to the question who decides what the law is in particular states. There is no simple answer. The judicial process is one that works through interpretation, and it works in a cumulative way so that judges, when faced with a particularly difficult question, try to reach the best interpretation of what has gone before and to extend that interpretation forward. And they disagree about what the best interpretation is, and you get divided courts. And then you get the lawyers in the legal academy writing articles, and then the judges rethink, and over the process of time, some view emerges as what the best interpretation is. It's a cumulative process, and when I say there should be an international common law of human rights, I mean that process should continue as if the judges in the various countries that are members of the international community were trying to work together in the way that the judges of any particular community work together. So, a court in London should see, as it did in the Pinochet case, that it is engaged in a collaborative partnership with the courts of all the judges of all the other communities. It should read what they have said, and it should try and build an interpretation of what they've said that can be defended in principle. Same thing as I've been arguing should take place within particular countries, interpretation in search of integrity, and I'm now suggesting this should take place among the nations. Your second question, I don't know whether you would find that a satisfactory answer. Some people, when they ask a question of the form, well, who decides that? They mean to ask it in a sort of skeptical tone of voice, as if to say, unless there is somebody who is the final authority, then there's something suspicious with the whole thing. But we don't have that in the common law. We don't have that within nations. We do have a system of hierarchy of courts, and when the Supreme Court speaks, the other courts are supposed to pay attention. But as we all know, every difficult and interesting case raises issues of how best to interpret what the higher courts have said, so that courts are always engaged in an effort to construct the best understanding. People often say to me when I talk about moral issues, people say, well, who decides what is morally right and wrong? As if there were a God someplace, and if only we had a telephone line or an internet connection with the moral God or with Platonic form, we would get the answer. But we have always to make a distinction between two things. One, is the truth demonstrable? Can I prove it the way I can prove a mathematical theorem? The answer in the case of morality and in the case of law is always no. I can't prove it in that sense. I can't prove it to the satisfaction of everybody. But I have to distinguish the question of demonstrability or provability from the question of truth. The fact that it can't be proved, finally, doesn't mean there isn't truth. I've got my view about what the truth is. You have your view about what the truth is. Sometimes people say, well, if you have your view and I have my view, there can't be any truth, meaning we're both wrong. But that's an indefensible philosophical position. I've argued that at some length in an article called Objectivity and Truth, and I won't burden you with that now, because that, unless someone wants to continue this. Your second question, who's a member of the community? Well, this is a matter of practical importance, because if let's say the Supreme Court of the United States cites the International Court in Strasbourg, and cites Mexican decisions, and cites the decisions, let's say, of Australian courts, and then some lawyer says, but may it please the court, there's a decision in Saudi Arabia that requires cutting off the hand and the foot of this criminal. Now, so the question arises, is a court in the United States, say, or Mexico, obliged to take into account the Saudi decision? If it does, this is going to distort the process. My answer is no, because, perhaps I shouldn't have taken that example, but I'll continue it. The Saudi government does not recognize the two principles that I described. There's a difference between acts that show a disagreement about how you respect the intrinsic value of human life and acts that are wholly inconsistent with any assumption of that kind. Certain states in the world now will not recognize the equal legal status of women. Any state that does not recognize the equal legal status of women does not recognize the two principles of dignity that I described. And in my view, courts in other parts of the world need not pay any attention to their decisions. But they do need to pay attention to a decision of a country that plainly is within the world of human rights and is trying to work it out, even when that country disagrees. The United States and, let's say, Germany disagree profoundly on what I take to be a very important issue, which is whether freedom of speech protects hate speech. As you know, in Germany, it's a crime to claim that the Holocaust, Hitler's Holocaust, was a fiction. The Jews invented it. In Germany, it's a crime to say that. There are people now in German jails, and there's one well-known author in a jail in Austria, for saying this. Now, to my mind, this is a violation of his human rights. But this is, I would say, a disagreement between cultures, both of which accept the general broad ideas of human rights. And I distinguish that from a disagreement across that idea, a disagreement in which some states don't, as is the case with those who subordinate women, don't recognize the basic principles.
Tengo 8 y déjenme entonces anotar a todos de una vez. Mena, Vázquez, Huerta, Cáceres, Cruz Parcero, ok. Entonces, Jorge. Bueno, Rodolfo.
Professor Dworkin, it seems to me that when you talk about the two principles of dignity, you have to conceive some kind of liberal theory for those principles. But not all the countries think about dignity in the idea of the liberal. So I would like to be more, if you can be more explicit about those two principles in the framework of the liberal theory, because I can think about, for example, Afghanistan, think about the dignity of women in the framework of a liberal theory, but maybe they have some idea of dignity. So, what do you think about it?
I suppose it's right that these two principles that I've described, as I understand them, are liberal principles. One is an egalitarian principle and one is a principle about liberty. I believe that these principles have certain implications which follow just from the definition of these principles. There are two principles. The Afghan view of the place of women, let's call it the Taliban view of the place of women, is inconsistent at least with the second, because that view of women does not recognize their right and responsibility to decide where the success of their own lives lies. It's a culture in which it is thought that the community defines the place of women and defines the choice that a woman has. You asked me to elaborate the principles a bit, and I'm uncertain how much you want, whether you want the 4-hour version or the 8-hour version. But I have written at length about this, but your example is a very, very good one for going a bit into the question. I think that the responsibility, personal responsibility, I call it ethical responsibility of each person for designing what counts as success in his or her life is basic. There are cultures that reject this, as you say, and believe that the community should define for the whole group of women where their best interests lie and where the success of their life lies. I would be firm enough to say they are wrong. That's a mistake. It's a mistake about the value of a human life and the character of that value. In my view, the value of a life is in the living of it, not in the consequences that it has for others. It's an adverbial value, as I call it. And it is of the essence of living well that you live according to your own standards, which is a burden for many people. Now, you rightly say to me, that's not a view everyone holds. Indeed, it's a view that only a small minority of human beings have held over the history of our species. It is, as you say, a liberal view. It's a post-Enlightenment view, which is even today not shared across Mexico, though I would suppose that it may be the dominant view in this room. So how should we respond to that as theorists? And my view is that we have a responsibility for making arguments in favor of basic principles and making such claims as these represent the basic human rights. This is a philosophical task. It's a task I tried to emphasize in which we have to distinguish demonstrability from truth. We do our best, and when I'm asked to give a lecture, I say, this is to me what defines the international community as to which we have a responsibility for integrity. And you rightly say to me, not everyone will agree with you. That's an understatement. Very few people agree with me normally about a lot of things. But that's the view that I'm prepared to defend.
A ver, yo sé que yo causé un poco de problema, pero trato de remediarlo. Entonces va de nuevo el orden. Cruz Parcero, luego Ochoa, Mena, Huerta y regresamos con Cáceres acá adelante.
My question is concerned with these last points about human rights. It's clear that we need to justify the basic human rights and to arrive to a basic notion of the basic principles. But I have some doubt that becomes to me reading your chapter 7 in your book, your last book, when you criticize the...
Now, which book are you talking about?
And the Justice in Robes.
In
the chapter 7, when you answer some arguments from Coleman,
yes.
You criticize the idea of abstraction strategy concerning the convention. Using your own arguments, but thinking in the moral matters and how we use abstraction to arrive to some basic principles, I don't know if your same points to criticize the strategy, the abstraction strategy, can be applied to your own arguments and to the efforts for many scholars or many philosophers to arrive to these basic human rights or to these basic principles. It's not, my point is not a critic to you because it's my own doubt about my own work and the work of many others.
Yeah, but you worry about the consistency of my view. Yes, on the one hand, I criticize people like Coleman, and on the other hand, something to do with abstraction, and on the other hand, I'm pretty abstract myself. Is that the question? Yeah. No, I don't think that's inconsistent because, if I recall correctly, I'm criticizing certain legal positivists because they use the idea of abstraction to claim convention. They say, I'm not claiming any convention. I'm not claiming people that this is true because a certain number of people agree on it. But that is what they're claiming, because the positivists are trying constantly to argue that each nation has a convention which is sufficiently dense to allow them to decide which claims of law are true. In the case of Coleman, when you point out to him that lawyers disagree about the fundamental test, he says, well, they disagree at a certain level, but if you state you can state a more abstract convention in which they disagree. And as I think I said in the chapter you're referring to, you would have to state a convention as abstract as this. Lawyers all agree that they should do justice. It's that abstract. And that means that the claim that this is a matter of convention is useless, because all the work then has to be done by moral reasoning. The convention doesn't decide anything. That's one point I make. The second point is, even at this level, it isn't a convention. Judges don't say, I must seek justice because that's what other judges do. They say, I must seek justice because that's my fundamental duty, whether or not other judges agree with this. So even at that level, it's not a convention. Now, in my own work, when I'm talking about the two principles of dignity, I'm not claiming that anything is true by convention. I would resist the claim that this is true by convention, because that would make my claim trivial. I'm claiming this is true. Now, a lot of people don't like it when I say this is true, because they say, who are you to decide what's true? Well, I'm just like you. You know, this is my opinion about what's true. We can argue about it.
Ochoa.
Well, I have two questions. They all three are connected. I was reading the essay of Jeremy Warren, the Rule of Law as a Theory of Debate, and he makes a point about one critic you answer to him about the right answer. How do we know when the right answer is legitimate?
How do we know when there is a right answer?
Yeah, and if this is necessary that go beyond the legal frames and start from the legitimacy points, sorry. The second question goes quite near to this. Richard Rorty writes about objectivity and relativism, and at some point I cannot avoid try to see the things you say from Rorty's point. When you start talking about objectivity and start talking about truth or my own truth, this is false in a relativity answer, and this may not work for law.
It may not work for law.
Yeah, because we make it particular, and we start getting problems like you write in your Law's Empire,
yes.
Which is the third question I have. In Law's Empire, you consider that one position that the law can take is when judges simulate some dissent about the law, and in the hard cases, there is only disputes about.
I'm sorry, could you say those words again? In the which case?
In the hard cases.
Hard cases.
Yeah, in hard cases, there's just only conflict about what is clear and shared, forming some sort of nihilism. Now, my question is, how do we make sure that we are not living such nihilism? How do we make sure that we overcome that nihilism? Because if you think that your truth is valid and there can be other truths, this can take you to two paths. Either become skeptical or either become nihilistic.
Is it communistic, or is it, what's the other choice I have?
Skeptical.
Skeptical, right. Skeptical, all right, well, thank you. Ima, are my answers too long? No, okay. Because someone asked me a question, I give a little speech, but if you mind that, just tell me to be shorter. These are all very important questions. What is the article by Jeremy Waldron?
The rule of law as a period debate. Please in this book.
Right. And now, how do we know there's a right answer? We know there's a right answer in the way that we know what the right answer is. That is, the question whether there's a right answer is the substantive question. Suppose that we're having a debate about some very fraught moral issue, abortion, for example. You might say there are three positions you might take. One, abortion is morally permitted. The next, abortion is morally forbidden. The third, there is no right answer to these questions. These are the three positions. You need an argument for each of these three. Some people suppose that if you lack a very persuasive argument for the first, and you lack a very persuasive argument for the second, then the result is that you must embrace the third. If you don't have a good argument, it's forbidden. You don't have a good argument, it's permissible. That shows that there's no right answer. That's a logical fallacy, because the position that there is no right answer is a third substantive position. You need a case for that as much as you need a case for either of the other two positions. Now, it's much more difficult to think of a case that one could make for the no right answer option. It's a little bit like science, you know. The claim of indeterminacy in science is about the hardest position to sustain. Once you distinguish in science between uncertainty and indeterminacy, then you see that you need an extremely elaborate theory along the line of quantum mechanics to defend indeterminacy. You might say we are uncertain whether there is at the bottom a fundamental law uniting the strong and the weak anti-gravitational forces. But and that we're uncertain is easy. That is the default position. But if I want to say more than that, not just we're uncertain, but there is no right answer to the question, I am making a very deep metaphysical claim. And I might have to sustain, that might be the right answer. Some people think that quantum mechanics leads to that result. But you need quantum mechanics. You need an argument that explains. Now let me go to the other extreme. Cases in which it seems to me, quite tempting to say there's no right answer. I've given examples from aesthetics. If you ask the question, was Picasso a greater artist than Beethoven? Then I'm very tempted to say, when you think about that question, you see there can't be a right answer to it, because we don't have standards for comparing performance in two very different art forms. Now, people would resist that. They would say, yes, we do have standards, but that's the argument. So to come back to your question, how do we know there's a right answer? We don't. We don't know. There are always three possibilities: yes, no, and no right answer. And the substantive challenge is, which of those three can we make the best case for? I think in law that it's hard for me to imagine a parallel to quantum mechanics. It's hard for me to imagine an argument that there is no right answer, because law is such a dense matter. It's a matter in which we're always dealing with standards that we have experience in comparing. We disagree, but we each have our private sensations of merit. So I don't know how you would show that there's no right answer to a legal question, but it's very, very hard to think how that could possibly be right. As always, the important distinction is between uncertainty, which is common and familiar, and indeterminacy, that is, there's no right answer, which is a heroically ambitious claim. I don't know how you'd ever be able to defend it in law, as I said. Now, second, if I'm talking too long, okay. Now, Rorty, I have had my disputes with Richard Rorty over the years, and you're quite right. Rorty objects to a lot of what I say about objectivity. But think what Rorty's arguments are. There's an important passage in an article by Richard Rorty that I like to cite. I'm afraid I've talked about it twice in print already, but it's a wonderful paragraph. He says, if the question arises, do mountains exist? Then, if you don't say yes, you're not playing the mountain language game. Of course mountains exist. They existed before human beings existed. They will always exist. They would exist if we perished. Whether they exist or not is not a matter of whether it's convenient for us to think they exist. They just exist as part of the objective world. Now, he said, when we're finished saying all of that, then we ask ourselves another question. Do mountains really exist? And now we're playing a different language game. Now we're playing the philosophical language game. And when we're playing that game, the answer is no. Mountains don't really exist. They're not part of real reality. They exist only because it's convenient for us human beings to talk about them in a certain way. Now, that's Rorty's, I think, developed way of dealing with the apparent paradox. You know, someone once said, the main trouble with pragmatism is it doesn't work. It refutes itself. And this is Rorty's way of responding to that. Now, that's got to be unsuccessful because there is no way that I've ever heard of distinguishing the meaning of the following two sentences. Mountains exist and mountains really exist. If you can't distinguish those two senses in meaning, then talking about language games won't help. Now, the reason I go through that story about mountains is the same thing applies to law and morality. Richard Rorty has very firm moral convictions. As it happens, in almost every thing that I can think of, I agree with his convictions. He's a weak-kneed, liberal, due process guy like I am. If you say to him, well, do you really believe it was immoral of us to invade Iraq? He would say, of course I really believe it. Then you say to him, well, but is that part of reality as it really is? He would say, no, that's just my opinion. Now, you can't combine those views. You can't, in one head, hold those two views unless you can show some difference in meaning. And in my article, Objectivity and Truth, I try and explore various ways you might try to make those two have different meanings, and I conclude you can't. Now, finally, how do we make sure that we've overcome nihilism? How do we choose between skepticism and communism, if I understood the last part of your question? Well, I hope we can, because I'm certainly not a skeptic, and I don't think I'm a communist. So how do we overcome nihilism? In my view, nihilism is best understood as an example of what I call internal skepticism. I suggest a distinction between two ways of being skeptical. One is Rorty's way that I just described. That is, you live your life the way everybody does, with very firm moral convictions. But then in your philosophical moments, you say, there's no truth there. It's just, I'm just like everybody else, expressing my opinions. I call that external skepticism, because it's external to the ordinary life of people. And I don't believe that that's a defensible form of skepticism for the reason I just gave. I don't think we have the semantics that would establish that as a coherent view. Internal skepticism is something very different. That skepticism that gnaws at your soul, that's real skepticism. When you actually think and act as if there's no truth in these matters. There are very few people who lead their lives that way. The great American judge, Oliver Wendell Holmes, I believe was a real internal skeptic. After the American Civil War, in which he fought, he said, I have paid the butcher's bill, and I know there is no God, there is no truth. There's just this horror. Now, if that feeling grips you, then I don't believe there's any way that a philosophy can talk you out of it. It's too deep. Very few human beings are actually gripped by this. Holmes was, and you can see it in his writing and in his judicial opinions. How are we not overcome, you ask, by nihilism? You simply say to yourself, is it important how I live? Does it matter? And there's no way of proving to you, if you think it does matter, there's no way of proving to you that it doesn't. If, however, in the dark night you think it doesn't matter, I don't know any way of proving to you it does. These are too deep. But the important thing is not to confuse these two forms of skepticism. Philosophical skepticism is skepticism on the cheap. It doesn't work, and it's just a pretense. The real skepticism, the kind that Gonzarov wrote about in his novel Oblomov, this life-destroying kind of skepticism, luckily, is very rare.
Thank you. I will give you more options, I promise, with my question. The question is very specific. What is your answer to ethical positivism? It's very important for me to know what is the next step of the whole discussion between positivism and you.
You mentioned ethical positivism.
Ethical positivism, like Waldron and another McCormick.
Tom Campbell as well.
Can you explain? I have never heard the phrase ethical. Legal positivism, I understand. But what is ethical positivism?
Well, you say in one article about Hart in January of this year that positivism recognize that they have one moral position when they choose the positivism. Behind, I don't know if the context is. Do you understand?
I apologize to you. I know what you mean. I use the term political positivism in the article I think you have in mind. And I use that term because Jeremy Waldron, in his article, I think used the term political positivism. But am I right in thinking that what you have in mind is the argument that we have good reason in political morality for asking judges not to take morality into account in their particular decisions? That's the view you have in mind.
Yes, it's important because here in Mexico, all the authority is from the legislator, not from the judge. The judge have one role different than in the common law.
Yeah. Yes.
And then here in Mexico, we need to know how it's important that the judges have this perspective, because they have behind his resolutions some kind of moral position, and we don't in the culture we don't understand that in at least in common the people. I don't know if you can explain more about this point.
Yes, good. Okay, let me apologize again because I just didn't recognize the term, and now I do know. I'm not sure, by the way, that McCormick and Waldron are examples of this. Waldron describes it. McCormick, I think, once held this view, but he tells me that he's now given it up, that his views are much more like the ones that I defend. But that doesn't matter. There are people. One very good example is Frederick Schauer of the Harvard University. And as I said in Justice and Robes, I think that's the form of positivism that is the strongest. So it's a very good question you ask. One issue is whether political positivism is possible. That is, whether judges really can decide without using their own judgment about moral issues. Can it work? Can it be done? In the classical or analytic positivism, the theorists like Herbert Hart or maybe Kelsen said, no, it can't be done, and therefore judges need discretion because the law runs out, and then they have discretion. And in the area of discretion, they exercise their own moral judgment, political judgment, as to what law to make. Now, that view is not available to the political positivist, because the political positivist says the virtue of my position is that we don't have judges making moral decisions. So that, for me, raises the question, is it possible? A very good test of that is I'm sorry always to refer to American examples, but they're the ones I know. Some of you may be familiar with the argument about originalism in the United States Supreme Court. Those judges who say they are originalists say that they are political positivists. The moral case for their positivism is democratic theory. They say in a true democracy, judges shouldn't be making law. Therefore, we look to the intention of the lawmakers, which is a historical question, not a moral question. It doesn't work. You can't, these intentions are too ephemeral. You've got to make moral judgments to decide which intentions to pay attention to. So that's the first problem with political positivism, and I think it's an insurmountable problem. Next, however, the question is, what is the moral background or the ethical background to which they appeal? I've just given one example of that, democratic theory. In my view, that appeal to democracy is an appeal to an impoverished view of democracy. I don't think it's a defensible view of what democracy is, because it holds that democracy means majority rule. And that's not, you disagree. Why don't you? Yeah.
Yes, that is the big problem between democracy and human rights, because democracy, in that point of view, majority is have one position in front of the human rights that all the people have to the authority have to respect the human rights of all persons. That point is very important, because if the judges have the responsibility for prevent that human right, that point is very important. I think it can.
Yes, and I agree with you, and I'm just making, you might think, too philosophical a point, that majority rule is not a good understanding of what democracy is. And my argument for that is not just verbal, I hope. Democracy is a value. We start from the idea that we're committed to democracy as something valuable. But majority rule is not just by itself valuable. There's no particular moral advantage in the view of more people. So in order to make democracy a value, we have to bring rights into the notion of what democracy is. Now, if that's right, then once again, political positivism doesn't have a sufficient background, moral background, by appealing to democracy, because it leaves open the question, are the conditions of individual right met? And the judge who says, well, I'm just going to assume that they've been met, is not doing the proper job. So then the question becomes, is there any other moral background that would lead to operational positivism, which would lead to telling judges, you just decide what the legislature has said? Jeremy Waldron does have a view, which, or at least did at one point have a view, that majority rule is fair, even if it's not the best understanding of democracy. It's what fairness requires when people disagree. I don't think that's right. I put to him this example. If you have a lot of people, standard philosopher's kind of example, if you have a lot of people in a lifeboat and one of them must be thrown overboard or the whole boat will sink, how do you decide which one? The last thing you would do is have a vote, because the unpopular one or the one with less friends will be thrown overboard. So you you throw dice or pick straws or something of that kind, you don't have a vote. It's only under certain circumstances that majority rule is fair, and that means when rights are protected. So it's a very good question, your question, and I think it's the important issue now. It's an issue mainly in political philosophy. And I'm not persuaded by political positivism, or as you call it, ethical positivism, but it's better than analytic positivism, for which there's nothing to be said.
Carla?
I have two questions, a bit complex. And the first one is regarding the meaning of the term principles and the way you use it when you speak about integrity and then about norms.
Yes.
And the second one I regretted, but I raised my hand when you asked if someone was interested in speaking about truth, and if you wanted to elaborate on the question of truth.
Okay.
So I don't know if you want first the question of truth or speaking of the other two ones.
Both.
Both. Well, okay.
If I'm allowed.
Yes, please, even if he doesn't allow it. Truth is, my question is, how can you speak of truth, of propositions of law, and what do you really mean about when you say propositional law? I think it's descriptive. And how can you, if it's not demonstrable, how can you really speak about truth? I'm sorry.
Okay. Now, do you think this is a special problem about law? That is the distinction between demonstrability and truth? You and I might agree about some moral issue, say Iraq. But there might be someone else in the room who disagrees with us.
No, I guess when you speak about propositions of law,
Yes.
I think you're speaking of someone said about the law.
Yeah,
So in a descriptive
yes.
sense. So we can take that and prove if actually that norm exists in that the determinate system. But I don't know if we can say that not killing anyone can be truth.
Yes.
Not harming a person can be truth. It can be a norm. It cannot be a norm. That norm can be valid. But I don't know if it can be truth.
How about the following sentence? It is a valid norm of Mexican law that you must not drive more than 120 kilometers on the highway. Is that statement true or false?
I guess it's false.
False?
In empirical sense.
But there's a true statement looking rather like it.
Yes, it could be.
Yeah, I mean, if I had said 70 kilometers,
that could be true.
That could be true. All right. So there's no mystery in how a statement, that's a proposition of law.
Yes.
There's no mystery in how a proposition of law can be true, is there?
Yes, in a way, because as I understand, you were saying truth is somehow connected to a correct decision.
Yes.
In the sense that it has a moral content.
Well,
that not all legal norms have a moral content. Most of them do, but not all of them.
Now, I'm just taking this one step at a time. That is, you said you can say it's a valid norm of the system, but you can't say it's true. And I'm asking you why that's so. If I can say it's true that it's a valid norm of the system, it's false that it's a valid norm of the system.
Yes, from the external perspective, you can say it.
So I can say a proposition of law is true or false. Now you raise the second, more important question. What are the tests of whether a proposition of law is true or not? It's not whether it can be true. Yes, it can be true. What are the correct tests to use? And you perhaps think that the test to use is simply the descriptive test. Is it a member of the set of norms of a particular system? But I then have to ask you, how do I decide if it's a valid norm of Mexican law? How do I decide? Now, My suggestion is that in some cases, you'll have to make a moral argument in order to show that a particular norm is, you can put it this way, a valid norm of the system. I have no objection to that. It's slightly verbose. I'd rather just say you can't drive over a certain speed, but if you want to say it's a valid norm of the system that you can't drive over a certain speed, that says the same thing. So what we're really disagreeing about is the old question whether moral facts are among the truth conditions of propositions of law. Mm-hmm. And what is and my view is yes, sometimes. And you say no, never? Is that your view?
No, I wouldn't say that. I think moral is an important component of certain norms, and it depends from the society, the culture, and historical grounds.
But which?
For many reasons.
But Herbert Hart said in the end of his career, in the postscript to his book, he said, yes, there can be norms which are valid, which incorporate morality by reference. Is that what you have in mind? Yeah. Yes. No, I think Hart was wrong about it. He was wrong in his example because he didn't know American constitutional law, and he gave as an example that I think he taking an example from me, he said the Equal Protection Clause of the American Constitution, which says no state shall deny citizens the equal protection of the law. He said everyone in America agrees that that incorporates morality by reference. Well, 5 judges of the Supreme Court would deny that. They say it's a historical test. So then the question is, how shall we understand this crucial provision of the Constitution? One group says it supplies a moral test. Another group says it does not. Mm-hmm. It simply stipulates a historical test. What did the people who made it think was equal treatment? My view is that you can't decide between these two interpretations without bringing to bear some idea about what a constitution ought to be. And if that's right, then not in the way Hart supposed, but in a deeper way, morality is at the basis of law. There couldn't be anything more important in American law than this provision. Now, why is that wrong?
You're asking me?
Yes.
Okay. I thought you were going to answer. What is there? No. Okay. The problem is I cannot accept the sense of truth regarding to norms from a prescriptive position, from a normative standpoint of view.
But I thought we agreed that you could accept it.
Yes, no. I can accept maybe it's the terms, the way we could say it's correct or adequate, but not truth. In a way, I have a problem with the term truth.
How about most adequate?
Most adequate would be wonderful. Yes, I would agree.
Wonderful. Now, I have to tell you
most
that...
adequate is adequate.
I think
most adequate, correct.
Yes.
Most correct, but not true.
No, I accept the way you...
No, look, what is important is not whether the word true gets used, but whether there's a uniqueness operator. And I have spent 4 decades of people saying to me, it's not true, it's just correct. All right. The important thing is the uniqueness operator. That is, do you make a mistake? Do you make a mistake if you choose another interpretation? And if the answer is yes, then I lose interest in whether you call it true or correct or most successful or most adequate. What's the difference? What is it about the word true that makes you shrink back?
The way you can operate with truth in a logical sense, the relation of norms in a system and the relation of propositions of law outside the
But it's the
system.
same, if you use correct as your operator, you get exactly the same implications.
Yeah, but if I use correct...
Correct is transitive. You get exactly the same
Results
logical functions.
without having the problem to demonstrate that you really have to respect your parents, for example, which is in the civil code in Mexico.
Yes.
There is a norm. It's
And it's
you
correct.
you are obliged to respect your parents.
Yes.
That is certainly a moral norm,
Yes.
and it's also legal norm. Is it true that you have to respect your parents?
Yes.
No, it's true. that
Oh,
in
it's
the-
not. Is it correct that you have to respect your parents?
It is true that in the Mexico, you are obliged to respect your parents according to the
Oh,
the code. And
okay.
it is true that according to a certain moral standard, you
Yes.
have to respect your parent.
Right, now,
It is not
good.
true that
Can we pursue this a little?
I am, of course, if you want, you can push
Because
it.
now we're talking, yeah.
maybe if you want, we can leave the truth for later on for you and me, and just answer the question about principles, because there were
Oh.
other people interested in
Well, I want to say, if I
Or you
can,
can ask you later.
one more word about truth. Because now you're talking about moral truth, and rather than legal truth. And so I have to ask you this. Suppose somebody wants to say about Mexico, in Mexico, the general assumption is that you have to obey your parents. But I think that's a mistake. I don't think you really have to obey your parents. I think that's just Mexican conventional morality. And I think a better morality would free you from that obligation. Is that nonsense? Well, if that's not nonsense, you've got the word true, because you can't then say that statement is just an appeal to a conventional norm, because that statement challenges the conventional norm. Okay, now the first question, which I did, principles and norms. You have to explain what the question is.
When you speak about integrity, you speak of integrity is coherence of principles, and then you use the term principles
Yes.
in a very general way. Then you give a certain classification of norms, say norms can be rules, standards, and principles. And I think there the principles are meant in a different way that principles is used the term and the way you
Well,
speak about integrity.
I see. I once made a distinction very long
Yes.
ago between rules and principles. And that's a distinction. Someone recently said I've abandoned it, which I think is unfair because it means that I have to keep repeating myself. People say, you gave that up. He does recognize that was Rex. No, I mean, that was a distinction I made in the course of a particular argument, and I think it's an important distinction, and it's being, I think, widely accepted now. But when I talk about, I do think that there are types of norms. One is a rule, one is a principle. I think it makes sense to talk about a standard as something different. An ideal is something different from a principle. To my mind, a principle states a demand, unlike an ideal. It states a demand, but that is not a rule. That is a demand that can yield to competing demands. Doesn't mean it's not important.
Cáceres, Enrique.
First of all, Professor Dworkin, thank you very much for your extraordinary conference, for your comments today. I have three doubts. They are related with the thesis that affirms that morality can be considered a condition of truth in the case of legal propositions.
Can you just repeat that, please?
Yes. It's related with the thesis that
Yes.
I feel that morality can be considered a condition of truth
Right,
for legal propositions.
right.
There are two traditional objections against that thesis.
Yes.
The first one is that it is not possible to talk about truth in the case of propositions on law. The second one is related with moral relativism. In my
Yes.
case, I won't refer to that objections because the discussion is very known. I would like to refer three different doubts.
Okay.
The first one comes from the field of general epistemology, and I feel that in the case of general epistemology, it is a little weird to talk that morality can be a condition of truth or some kind of proposition, mostly if we consider the possibility of the moral relativism. Except if we consider a coherent theory of truth.
Coherence. Yeah.
Coherence theory of truth. If that's the case, I would like to know what is the version of coherence theory of truth that you subscribe. The second one is related with legal epistemology. In that field, the problem to determine the truth or falseness of one legal proposition is related with evidence, problems related with proofs. I feel that maybe it could be necessary to introduce a stipulation in order to distinguish both kinds of concepts. The problem of truth related with moral as a condition of truth, and the problem of evidence and proofs as a condition of truth of other kind of legal propositions. And the third one is, I wonder if your interpretative theory is not proposing a condition for determining the truth of legal propositions, but if it's not better understood as a new rule of recognition, in which principles which determine what is the best interpretation could be considered the rule of recognition, the new rule of recognition. But if that is the case, it arises for me a new problem. The problem about the possibility to provide an autonomous concept of law, which has been the specific goal of legal positivism. Thank you very much.
Well, thank you. Those are very deep and important questions. I'm not sure I understood the last one thoroughly, but we'll come to that. You ask whether my account presupposes a coherence theory of truth. I believe not, but it does presuppose a coherence theory of falsity. That is, I believe that coherence does not guarantee truth, but non-coherence guarantees falsehood. And that's because I don't believe in deep moral conflicts. However, I think probably I shouldn't try and explain all that, but there's a substantial section of the book I'm now writing, which is called Justice for Hedgehogs, does take up exactly that question. And I think I better postpone the answer, but just leave it that I don't accept a coherence theory of truth. I think you can have, in morality, I think you can have a very coherent and horrible theory. But I also think coherence is a necessary but not a sufficient condition. Now, the problem of evidence, there's a very important distinction, I think, to be made between domains in which evidence is available and domains in which evidence is not available. And this depends on a distinction of the following kind. In some areas of inquiry, conspicuously science, the way in which we come by our opinions also provides an argument for the truth of those opinions. So we can say, why is it raining outside? I hope not. I look outside and I see the sunshine, and I say, it is not raining outside, because I didn't see the rain. And that is an argument that it's not raining. The best causal explanation of how I came to think the proposition true is also evidence of its truth. And I think that is in general a feature of scientific inquiry. The way in which I come to think that there is water on some planet around a star in a distant galaxy involves a nested set of observations. But I can say, if there were no water there, I wouldn't think there is water there, because I wouldn't have the observations that produce that thought. Now, in the, I think I would say, 17th century, the opinion began to form that that requirement is a general requirement of knowledge, that there can be no truth in a domain unless the way in which the best, let me put it this way, there can be no truth in a domain unless the best causal explanation of belief is also evidence of truth. And the word evidence came to be used in that way. If, let's call that the epistemological premise. If you think the epistemological premise is a condition of any knowledge, of any truth, then there can be no truth in morality, because there can be no evidence for morality. But I reject that epistemological premise. And so do we all. It's a case of scientism, of taking that proposition which holds true in science and supposing that it's a general condition of truth in any domain. It's not a condition of truth in morality, I believe, because unlike here I divide from many other moral realists. I don't believe morality is a matter of perception. I believe the best explanation of why I hold the moral opinions I do has nothing to do with their truth. It has to do with my own biological makeup and the culture in which I was raised. I believe that had I been raised in a very different culture, I would have very different opinions. If I had been raised in a military family in the American Southeast, I would probably be a Republican. I shudder to think of it, but I have to admit it. Now, if you hold the epistemological premise, that's good reason for saying, first, there can be no evidence of a moral belief, and secondly, that means there can be no truth. But I just dismissed the premise. It's a mistake. But again, I need a much bigger argument for that than I can give you now. So I appreciate the question, but I have to ask you to wait till I finish the book.
Paulette Dieterlen, y luego les digo que están en el orden, Carlos Pérez y...
Professor Dworkin, I'm going to change the subject a little bit. I'm really sorry we were all, because I'm not a lawyer. So yesterday and today and all your work, we know that equality matters. It's a very important principle. And my question is a little bit Amartya Sen's question. Equality of what? Well, I wanted to know if you still think that equality of resources is a good principle of distribution. But I don't know either if he can answer me, because it's not a philosophy of law.
No, it's part of
It's politics.
So the question is, do I still believe it?
I have to make the most of it. You being here.
Well, I
yes,
think-
if you still think that equality of resources is a good principle
Yes,
to reach equality. No?
yes, I do. Now, what is your objection to it?
No, well, no, it's not objection. It's only the way that this principle is important for the discussions about primary goods, capability,
Yeah.
coins,
Yes.
access to equal opportunity, and that's
Well, maybe I should say a general word. I keep worrying that I'm taking too much time, but let me say a general word about the background of this question, because it may not be a matter of general knowledge here. But among people who believe in equality as a political value, or who believe, as many people now prefer to say, the reduction of inequality is a political value, you need to answer the question that Amartya Sen put in this form. Equality of what? How do you tell when people are equal or less unequal? What is the measure or the metric? Or as Jerry Cohen said, the currency. And there are various views in the field. One view still strongly held is equality means equality of well-being, welfare. If people, it doesn't matter that people have the same money, it matters whether their lives are somehow going well, and they should go equally well. That's the dream of equality. And I argued against this, that we can make no sense of that, because we can make no sense of welfare as something that you can compare and distribute equally. Another choice is a choice recommended by Amartya Sen, which he calls the capabilities approach, and another is another is John Rawls's test of primary goods, and another, as you say, is my own favored description, which is equality of the resources people have available. They all have a certain merit, and the problem is which, in the end, they all require elaboration, all these answers. As I say, equality of welfare seems to me not a good candidate. I don't like equality of capabilities as Sen described it, because it requires a list of capabilities, and that list can't itself be defended, and the list might be controversial. Amartya has a very complicated way of defining capabilities, but he includes, and this I think is a very revealing matter, he includes self-respect as one of the things that we should aim to make equal, or the circumstances of self-respect, and I think that's a mistake. I think self-respect is a matter of individual achievement, and not something that we should strive to make equal. So my preferred answer, pretty complicated, is to try and separate those things for which we should be personally responsible from those things that it's fair to say should be made equal for us. And I therefore suppose that it's up to us to define success in our own life. What matters, which kinds of capabilities are important to us. That's part of our responsibility for leading our own life. But it's up to the economic arrangement to distribute the resources that we need in order to carry out our chosen plan. I believe that these two must go together. That is, that we must find some way of identifying resources in a community, which means not just wealth, but freedom from certain kinds of handicaps, that we must find some way to work this out so that people have the same share before they decide what to do with their lives, because I think it's part of our responsibility to make a plan for our life with a sense of what our fair share of resources is, so that the challenge is internal. Make the best life given your fair share. It's one of the reasons I reject welfareism and utilitarianism, because it doesn't allow people to do that. There are challenges to this. There are difficulties in working out this distinction, because as I say, I want it to be worked out in advance of people coming to make their own plans for their own lives. How do we handle, for example, bad luck in the distribution of resources? You might say, bad luck shouldn't be, it's not a matter of your own choice. It's something that happens to you in spite of your own choice. So it should be something that society makes equal. If you have bad luck, you have an accident, society should put you back in the same position. Or if you make an investment and it goes wrong, or you train for a job and there's there's technological unemployment, and suddenly you're out of a job, that's not your fault, that's not your choice. Society should put you back in a position of equality, reinstate equality of resources. My argument is that that's an unfair as well as an unrealistic approach to equality, because it's equality ex post. It's equality as you lead your life, constantly readjusted. And after some attempts, I came to the conclusion that what we need is equality of resources ex ante, that is, before the various events happen. But this, I'm now compressing a very long argument, but this requires, in my view, genuine ex ante equality, genuine equality in advance. And that means equal opportunity to insure yourself against bad luck. People don't have equal opportunities to insure against bad luck because some start off poor and they can't afford the premium. Some start off genetically handicapped already and they can't get insurance. So in Sovereign Virtue, I described what I call a hypothetical insurance argument. And the nerve of that argument is that we should imagine what the premium would be for an insurance policy against various forms of bad luck if people had equal wealth and if people had equal risk of bad luck happening. We can do that. There are insurance models that tell us what the cost would be under those assumptions of certain kinds of policies. We should ask, what is the minimum policy that it would be fair to assume that everyone would buy? That's a question. We need information about the particular technology of the community and the particular risk aversion of ordinary people in the community. But I think we can come to answers about that. And then we construct a tax system, and the tax system extracts from us all an amount equal to the premiums we would all have paid for this insurance. And when one of us gets handicapped or sick or unemployed, then you get the payment that the hypothetical insurance would have provided. And that means that society can always afford to make that payment, because by hypothesis it's collected enough in taxes to pay the premiums. there are certain complicated mathematical structures you have to work out to see this. But I think it's perfectly feasible. What would the result be? The result in Mexico, let alone America, would be a welfare system, single-payer medical plan, unemployment insurance far above what these rich nations or developing nations now afford. It would be a redistributive program well beyond what nations now do. It would have to be done globally, because otherwise there'd be competitive disadvantages to worry about. But it would not achieve full ex-post equality. You know, you wouldn't get back. Just think about it. You couldn't afford an insurance policy, and it would be irrational to buy an insurance policy that would pay you the same wage that you were earning after you became unemployed. No insurance policy would be rational that would have such a provision. It would cost too much. So the result of this equality of resources, as I envision it, would be a redistribution far in excess of what we now have, a redistribution that we could afford, redistribution that was sensitive to all the features of people, of technology, and of people's risk aversion, but which did not achieve the completely unrealistic goal, which I've called flat equality. Now, your question is, do I still believe it? The answer, as I hope became evident, yes.
Thank you very much. I want just to explain it for us again.
Carlos.
Hello.
Hello.
I just have one question. What do you think about the influence, if any, of Stanley Fish's theory of interpretive community in your theory? Do you think you have to deal with something similar to Fish's ideas, or you can present a completely different case? Do you need interpretive communities at all, or not?
Stanley Fish presented his idea in a skeptical way. You know, the title of his first book is their text to this class. Stanley Fish was for a time on my case, as he would put it. He wrote several articles saying that I had misunderstood everything. So yes, I have to deal with Stanley Fish. At least I did once, but I tried to do that. His idea begins in the assumption that we can make no sense of interpretive truth. We can just make sense of interpretive power. That interpretation will succeed, which a community has decided should succeed. I reject that. I think it's based largely on the confusion I talked about earlier between uncertainty and no right answer, in uncertainty and indeterminacy. So I think the philosophical basis of Fish's original arguments are very poor. However, he and other critics have provided something very valuable if we consider it under the heading of sociology of interpretation. Because it's perfectly true that interpretive communities form. I don't think he's right in supposing that these are political battles, like the battles between the Mayan kingdoms about killing each other and executing each other afterwards by denying tenure and all the things that Stanley Fish worried about. But I think something deep is illustrated in the fact that over time, the standards generally accepted in various communities, the legal community, the literary community, the biblical community, for a successful interpretation, correct, true interpretation. These standards change. And I think we need a theory of interpretation, a general theory of interpretation, which can explain this, which can explain why changes. So, for example, if I said to you, in general, when is an interpretation successful? And by general, I mean across all the domains of interpretation, legal, aesthetic, historical, and all the rest. When is an interpretation successful? Or, to put it another way, what is interpretation aiming at? And someone gave me the answer. Interpretation, in its very nature, aims at retrieving the intention of some author. There's a creator of a poem, and interpreting the poem means trying to guess what he intended the poem to say. If we have that as our general theory, we can't explain this shift, these interesting shifts in what is taken to be success, which Fish describes. So we need a different general theory of interpretation. Luckily, I have one. And my theory is that, well, I shouldn't call it anything so grand, but my view is that, once again, in response to your question, I try to say something of this kind. We have to distinguish between the domains of evidence and the domains of purpose. Interpretation is a domain of purpose. In science, the reason why we're conducting the enterprise doesn't figure among the conditions of success in the enterprise. It doesn't, it can't. It's a confusion. It's bad pragmatism to think it does. So I may say, I am interested in cosmology because the mysteries of space are enchanting. Good reason for being interested in cosmology. But if I then said, and a theory is true that enchants me, when I find a theory that really enchants me, that's true. That would be a mistake, because you shouldn't confuse the purpose for which you are investigating with the conditions of success of the investigation. However, in the domains of interpretation, that is exactly what you should do. The success in the interpretation depends on the purpose of the investigation. Since, and this is by the investigation, I mean the collective enterprise, the sort of thing that Fish calls a community, which goes about having arguments and doing research. And you have always to ask, what's the point of doing this? And the point of doing it is going to be provocative once again, be among the truth conditions of success. I think that's true about law. I tried to make that case. But let's think for a moment about literature. And think about the historical shifts among literary scholars and critics about the connection between literature and morality. There was a time, the time of Bloomsbury, for example, the time of the great Cambridge critic F.R. Leavis, in which it was assumed that part of the point of great literature was moral enlightenment. We're in a very different age now. We're in an age where one of the defects of a work of literature is that it's preaching some moral case. Now, when you get a shift like that, you get an entirely different kind of interpretation. And that's an illustration of what I'm trying to suggest, which is the interdependence between the general assumptions of the activity and what counts as success within the activity, general assumptions of why we're doing it, and success. The risk is that when I put the matter that way, people will say, here's skepticism back again. Here's relativism back again. Because what I'm really saying, I'm sure some of you are thinking this, is it's all relative to the community's expectations and assumptions. But that temptation disappears when you say, as I would like to say, but there's a right answer to the question, why should we be doing this? What's the best justification? Very complicated answer. In law, it's obviously got something to do, why we interpret. It's got something to do with justice and political morality. Law is legal interpretation that way very different from interpreting poetry. But what does it have to do with it? What more precisely are we aiming at in the process, the interpretive process of legal reasoning? Well, my view is we're aiming at integrity. That's the thing to see ourselves as justifying, and hence yesterday's lecture. But it's like a tree diagram. People step in different directions off the trunk of the tree at various stages in the height of the tree. So someone might agree with me, it's about legal interpretation, is about justice, political morality, how to make a better community, and disagree with me that integrity is the aim, that the pragmatists, Posner and company, are exactly that. They disagree with me that integrity is. I want to say that's not a triumph of relativism, it's just an occasion for a very deep argument, whose view is right. Some people might follow me about integrity, but then say, for example, to go way up the tree, you have to find coherence not just in the verdicts that judges reach, but in the arguments they give. And we can't find coherence in that. That's what the critical legal studies people said about some of my arguments a long time ago. I want to say this tree structure in which people disagree at many levels, some of them basic, some of them in the capillaries, some of them just down towards the leaves, are going, two things. They're going to account for the difference among lawyers and legal theories. The deep ones are going to be differences in schools of jurisprudence. The ones towards the periphery are going to be disagreements about how to decide particular cases. So this will account for difference, but it's not an occasion for relativism, because all the way back down the tree, including at the most basic level, there's argument to be made and decisions to be made. What do you think the truth is about this?
Álvaro. Javier Ortiz, perdón.
Professor Dworkin, according...
Yeah. According to your last book, Is Democracy Possible? If I understand you, it is not always the case that individual rights are trumps over the majority in view of phenomena like 9/11, terrorism in general. Could you say a word about this change of view, if that's the case, please? I will appreciate your answer.
Yes, you mean the change that you're thinking. Well, you first said individual rights are trumps over the views of the majority. I think that remains true over 9/11. It makes it harder to defend this claim. We are now in the American community suffering from, I believe, a misconception of what rights are. This is most vivid, not in America, but in Britain. The Home Secretary, the person in charge of the police, made a speech recently, which I responded to, in which he said, we have to understand that individual human rights were once important, but now they're not important anymore, because they were important after the Second World War, when all these treaties were signed. But 9/11 and the reign of militant Islam just means that those rights are no longer pertinent to us. And we have to reestablish a different criminal process in which defendants can no longer escape justice by talking about their rights. This is, of course, I shouldn't say of course, this is, in my view, a complete misunderstanding, but a very popular one. This is the understanding of rights that supposes that rights don't cost much, that we recognize rights when it serves our purpose. It's a kind of consequentialism like utilitarianism. When we can respect rights without imperiling our security, then we should respect them. But when they get in the way, we can dispense with them. There's a metaphor that's very commonly used to express this view. The metaphor is, we should strike a new balance between security and liberty. That also misunderstands what's going on, because it sounds like we should readjust the speed limits on our highways. When accidents are increasing, we should lower the speed limit. When we're in a stretch of road that's perfectly safe, we can raise the speed limit. The mistake is once again to think that it's our own convenience. We're trying to get the right balance to respect our own convenience. Now, my view is that rights have an entirely different place. Rights cost something. We believe in them because we think that human dignity is itself something to be protected, going back to the two principles I mentioned. We think these are important principles and they're worth sacrifice. We've always taken that view. In this country and in my country, we have problems with drug dealers. If we were to change the criminal law so we could arrest people with very little evidence before they'd actually committed crime, probably drug crime would be reduced. A lot of innocent people would be in jail, but drug crime would go down. We don't do that. Why? We pay a price by not doing it. There are more drug murders than there are victims of terrorism. We won't eliminate the traditional rights of the criminal process because we respect the principles of dignity that sponsor those, in spite of the fact that we pay a cost for them. When something like 9/11 comes along, we say, oh my God, look at the cost. But that, if we really accept this new balance idea, then it seems to me we've just covered ourselves with dishonor. I said once in some meeting, death is not the worst thing. We're all going to die sometime, and we're much more likely still to die while crossing the street in Manhattan than we are from a terrorist. Embezzlers, white-collar criminals, people who steal pension funds from companies that mean that the workers will end with no pensions, are responsible for much more misery than the terrorists. We don't put them in jail without trial. So the answer to your question is, we're in trouble on this score, but we have to hold firm.
I guess we have a lively discussion, and by now everyone on the list is all gone. I will also only like to thank you again for this kindness of you of not being only giving a lecture, but insisting on having this discussion, this exchange with the people here. So I think it has been very lucid, and it has been very brilliant, and it has been very enriching for everyone here. So I will also just like to thank you again for all this.
Well, thank you. I didn't. I mean, I insisted on this out of my own self-interest, and I've enjoyed it very much and profited. Thank you all very much.
Thank you.
Good.
Thanks. Do you think that